Thank you very much for coming. Welcome to Hong Kong U SPACE. I'm Danny Gittings. I'm Head of Law Programs here. And it's my very great honor to welcome back my predecessor as Head of Law Programs for far longer than me. He was Head of Law Programs for 25 years here at Hong Kong U SPACE, Mr. Michael Fisher. And we're very pleased to have Mr. Michael Fisher back at Hong Kong U SPACE. He taught me when I studied here on law programs. He was the head of, in fact, he brought to Hong Kong what is the most popular part-time law program in Hong Kong. He's going to be talking to you, he's going to be teaching here again, starting in the autumn, and he's going to be talking to you about one of the first-year subjects, Tort, which whatever law course you do, whether it's with Hong Kong U SPACE or anywhere else, one of the basic subjects studying law is tort. So a very good introduction to something that comes right at the beginning of studying law. But first, if I may, if I can just steal just a couple of minutes, I'm sure you're here, you're interested generally in law, but because Mr. Fisher was the director and indeed founded the most popular part-time program for studying law in Hong Kong. And because we're actually in the final phase of selecting applicants this year, let me just say just very quickly a few words about that, and then I'll pass over to Mr. Fisher. The program I'm referring to is the CPE, the Graduate Diploma in English and Hong Kong Law. Mick, you came to Hong Kong to set this up, didn't you?
I did. That was my first invention in 1991.
So you can see from, and then I studied it a few years later, you can see from what Mick said what a long-standing course this is in Hong Kong. And we were the first to have this course in Hong Kong and still by far the best established. Students do this course for many, many different reasons. But the predominant reason, and the reason which really distinguishes the course we offer from courses elsewhere, is because it provides a much better pathway to the legal profession in Hong Kong. And I think some of you have heard of the PCLL. The PCLL is the only way locally as qualifying as a lawyer in Hong Kong. And every year, and Mick, you had this experience when you were here as well, right? We have large numbers of students going on to PCLL. And Mick, you must know so many students now who are in practice in Hong Kong, right? Yeah, sorry, I forgot to mention it. Of course, we've basically been going so long, some of our students even gone on to become judges. The crucial difference between what we offer and what other institutions might offer is if you go all the way through our program, and we have an extension, an optional third year, you go all the way through our program, you cover all the subjects that's needed for the PCLL. So you don't actually have to, there's a very complicated list here. Okay, you don't have to worry about taking extra exams if you want to continue on. And that's why we have this excellent success rate. There are far more students on the PCLL than any other English law course in Hong Kong. Some of them even actually getting government subsidized places. So that's almost all I wanted to say today, except just to say, if you do decide that that course is for you, we are actually now in the final stage of this year's application process. Very popular course, normally 400 to 500 applications a year. But there's a large course, so there are also a large number of places, and basically the earlier you get your application in, normally the higher chance you have of success. The application deadline also coming up now on the 3rd of July. There will be application forms in the brochures on your seat, so if you do decide that's something for you, then you just have a look at that. That's all from me. I will be here. I'm looking forward to hearing what my predecessor had to say, and if any of you have questions about the CPE or anything about Hong Kong U SPACE law, you're welcome to ask me later. But in the meantime, over to you, Mick.
Okay, thank you, Dr. Gittings, for that very nice introduction. So, just before we start, I am not going to teach you the law of tort in less than an hour, and I'm not even going to teach you the law of defamation. But just as a taster, I'm going to tell you some rather strange things about this one particular tort, defamation. Okay. One of my favorite tort academics, Tony Weir, who died unfortunately far too young, said this: defamation is arguably the most difficult of all torts. It's certainly the oddest. For instance, defamation is the only tort in which A, liability is extinguished by the death of either party, trial by jury is available at the instance of either party, and legal aid is not available to either party. It is those three oddities that I'm going to focus on today, simply that. Before we start, but I'll make this clear as we go along, trial by jury is pretty much gone now in Hong Kong and in UK, but the other two odd things that Tony Weir flags are very much still with us, and they do have great significance both for the law of tort and also for tort practice. So, a few words of explanation, and then I'm going to look at those three oddities. First, if I'm talking about a strange tort, you want to have a basic idea of what I mean by tort. We generally divide up law, whether it's in England or in Hong Kong, into criminal law, which is the sexier bit that you know all about, you know, people shooting other people and etc., but actually is a very relatively small part of what you'll be studying, and civil law, which involves obligations owed by one party to another, in which someone is injured and seeks compensation from somebody else. The somebody who seeks the compensation is in Hong Kong as a plaintiff, and the person he's trying to get compensation from is called the defendant. So, tort. The law of tort involves those rights and obligations which arise not through agreement in any other way. If your rights and obligations arise because you've made a binding agreement with somebody, now we're talking about the law of contract. So tort, all those rights and obligations which arise other than through agreement. You walk on across the road on the proper crossing with a green walking man, and as you do this, a car driver, not looking where he's going, knocks you over. Of course, he might be arrested for careless, dangerous driving, whatever. But from your point of view, the victim, you want compensation. You want monetary compensation known as damages. And you do this via the law of tort. And the particular tort in question there would be the tort of negligence. Easily the most important tort and easily the most common one. Sorry, going backwards. So, if I make a binding agreement to buy or sell a car, the buyer and the seller have made a contract. If A carelessly knocks down pedestrian B, B may wish to sue for damages to compensate for the injury, and B's action will be in tort. In fact, as I mentioned, the tort of negligence. The tort of defamation. Again, before we look at Tony Weir's three oddities, we should quickly ask what defamation is and what interests it protects. Defamation involves the publication, and I'll explain that word because it isn't as you think, publication in a book, magazine, whatever, it doesn't need to be, the publication to a third party of a statement about the claimant, the plaintiff, if you wish, claimant, in fact, in England, plaintiff in Hong Kong, which tends, if believed, to lower the reputation of the claimant in the eyes of right-thinking members of society. Now, we haven't got time to look at the definition of defamation in more depth than that, but basically, someone has said something about you which, if it's believed, and people may not believe it, but if it is believed, it would tend to lower your reputation in the eyes of the reasonable person. Okay? That's a defamation. Now, what do we mean by publication? It simply means that you convey your insulting comments, your defamatory comments, to someone other than the person you're insulting or defamed. So, for example, if I decide I don't like you, and later we're in a room together, and I say you're a liar and a thief, and etc., that is not a defamation because no one else is going to hear it. On the other hand, if I say it to you now, with all these witnesses, I have indeed published, and it would amount to a defamation. So, mere insult, no. Defamation if it's published. Now, you sometimes, because we always try to set difficult questions, don't we? So, suppose, this is the example I give my students. I say something insulting about you, thinking it's just you, I'm just having a go at you, and there's a student asleep under there because he went to my last class and didn't really find it very interesting, okay? He wakes up and hears the insults. Might be a publication. Well, it would be if I thought it was likely that he'd be there, but if I had no reason to think he was there, maybe not a publication. That's the sort of narrow dividing lines that make law in particular and tort law interesting. Defamation, then, is the tort which protects reputation. Keep going backwards. Defamation has two subtorts, libel and slander. Now, the layman, not having come to law before, says, I know the difference between libel and slander. Libel is written and slander is spoken. And that's kind of almost correct, but it's rather more sophisticated than that. Essentially, libel is a defamatory statement that's made in some sort of permanent form. So it could be in a book, it could be in a newspaper, in a magazine. It has been found to be in a waxworks museum, and so on, okay? Even though those waxworks are likely to be taken down and melted down in a few years. So permanent, we don't really mean permanent, but we do mean fairly long-lasting. But if I merely abuse you in front of a lot of other people, that's only a slander. Now, I will give you an example of a slander. There was a case a few years back involving Virgin Airlines, and the plaintiff in that case got on a plane and, or rather, he tried to get on a plane. He had a ticket to get on the plane. He'd just been to a religious meeting, and all his friends were waving him off, and then suddenly, Virgin Airlines ground staff in Nigeria said, we're not letting you on the plane. We think you're a criminal. He went, oh, of course I'm not a criminal. I'm a perfectly respectable guy. But they didn't let him on the plane. So what happens? He has to stay in Nigeria for a while he's clearing his name, organizing a new flight. And this is what he says happens as a result. While he's in this lengthy stay in Nigeria, which of course he didn't want to happen, he was robbed. And then he also claimed that because he was away from London so long, His fiancée had come from Germany to wait for him in London. When he didn't get back for several days, she said, right, that's it, and broke off the engagement. So he brought an action for breach of contract and said all of these things I should get. No, said the court, you can't really expect that that breach of contract would mean that your girlfriend would ditch you or that you're going to get robbed. You can get, however, you can get damages for having to buy the new ticket, the cost of your hotel stay, and etc., right? Now, so that's fine. But what about defamation? Because surely his reputation was offended in front of all his friends. Problem, it wasn't a libel, it was a slander, because there were insults but nothing in permanent form. And the rule is that you can only bring a slander action in the place where it took place. So yes, he could have gone all the way back to Nigeria and brought a slander action, but he wasn't going to do that. So he couldn't bring the action in UK. One of the important things about libel, something in permanent form, it may be distributed in many, many places. So libel is more useful to you as a plaintiff. A few years back, there was a case involving Cameron Diaz. Anyone heard of Cameron Diaz, the actress? No? Cameron, yes. Cameron Diaz, yes. And this is what happened. She had a dispute with the National Enquirer. She said they defamed her. So she sued in London. Why didn't she sue in America? Because America has greater protection in this context for freedom of expression. So it says a plaintiff can only win a defamation case if he can prove that what was said was untrue. Whereas in Hong Kong and in England, you don't have to prove it's untrue. You merely have to prove it's defamatory. If the other party wants to allege that, well, it isn't defamatory because it was true, then that's a defense, but it has to be pleaded, and the defendant has to prove that what he said was indeed true. So she comes to London to sue. How could she do that? Well, even though the National Enquirer is an American magazine, of course some copies or some online hits took place in England. And therefore, that gave you the jurisdiction to bring the case there. So all I'm saying really from this is libel can be much more useful for a plaintiff. Number one, because there's a permanent record. So you can say lots of people could see this. That's much more damaging to my reputation. And there is the potential for bringing the case other than where the insult was made. So, libel then likely to be more serious because the permanent record remains for others to see. Okay, let's go on to Tony Weir's oddities. 1, the effect of death. In all other civil matters, rights and obligations survive the death of the parties. For example, if I owed you money at the time of my death, you could sue my estate for it. Now, we won't go into what constitutes an estate, but if you're married, it will usually be your surviving spouse, and there will be a procedure whereby they are given the right to manage your estate for you. So, very simply, I owe you money. I die. Does that mean, oh no, you've lost your debt? No, it doesn't. You can sue my estate. Or you owed me money, and I had the right to sue you, but before I did it, I died. My estate can sue you. That is called survival of action, and it applies to almost every tort, indeed every tort, except defamation. Defamation ends when either the defamer dies or the defamed person dies. You cannot defame the dead. Now, you've probably never noticed this before. I told you, maybe you will. It's much more likely that insulting, defamatory statements are made about people after their death. There's all these rumors going around, okay? But everyone is just a bit too, oh, if I say that, maybe I'll get sued. Soon as they're dead, oh, this guy was a terrible businessman, you know, he never paid his debt, etc., etc., etc. And all that kind of thing comes out. All those rumors that were just hidden as skeletons in the cupboard now come out because the person is dead and no action can be brought, even by his loved ones. And they may be very upset by this. You know, you've just called my dad a thief and a liar. Nothing you can do. Defamation is different. If the defamer dies, the defamed person's right to sue. If the defamed dies, his right of action dies too. So you cannot defame the dead. Now, where's oddity number 2? There may be a jury. It's very unusual in civil, in non-criminal cases, to have a jury. It's much more common in criminal cases. It's not even that common in criminal cases. And it's becoming even perhaps less so in such cases in Hong Kong which may involve national security. But as far as civil juries are concerned, very, very unusual. Less than 1% of all civil cases will be heard with the jury. But insofar as it does happen, it's almost certainly going to be defamation. There are one or two others, maybe false imprisonment, but generally speaking, we can say defamation. And the most important Hong Kong libel case in recent times was a case called Liu and Chan. And one or two of you might just remember this. This case involved assertions by Paul Chan, who was then and still is a Hong Kong government minister, and he wrote on emails and so on, asserting that the Liu twins had cheated in their exams. And he also added that the reason they got away with it was that their daddy was on the board of governors, or the school board. So he's essentially defamed them all. He said that the two children are cheats, and that the dad has covered up the cheat. Okay. All the three of them then sued him for libel. The case was heard by a Hong Kong jury, although their decision was later appealed all the way to the Hong Kong Court of Final Appeal, where, of course, there is no jury. We don't have jury in the appeal courts, the Court of Appeal or the Court of Final Appeal. And the Court of Final Appeal ordered a retrial. And as far as everybody knows, that's where it stays. I suspect that there must be efforts now to settle this finally, because it's been dragging on for many, many years. But the last I heard, we still were in this position. So I'll quickly run through this. It's a bit technical. The jury heard the evidence, and they said Chan had definitely defamed these three. Complication, juries don't give reasons. Judges have to give reasons, juries don't. So we don't know exactly why they found this was defamatory. But what seems to have been the case is this. That situation was what is known as qualified privilege. That means that everybody on the school board was very concerned about the school's reputation. Of course, they didn't want any accusations of cheating. They didn't want to have any dishonesty on the part of the pupils or the school. And therefore, a person like Paul Chan, who was a parent in the school, had an interest in conveying his concerns to other people, and they had an interest in listening to that. Now that is what's called qualified privilege, but is defeated by malice. That means ill will towards the person you've insulted. And what seems to have been the case, though of course we don't know because they don't give reasons, is that the jury thought, yes, this was a qualified privilege situation. He did have an interest in conveying his concerns. People out there did have an interest in keeping the good name of the school. But Paul Chan had made these statements with malice. On appeal, the Court of Appeal threw out the finding and said that the jury had got things wrong. It then went to the Court of Final Appeal, which said that the Court of Appeal had got things wrong. And they ordered a retrial. It's got to go all the way back to the trial judge. We accept that the statement was damaging. We accept that they suffered loss as a result. The one factor that the first trial has to decide again is, was there malice? But so far, that new trial hasn't taken place. I suspect that the parties are trying to reach a settlement, but we can't be sure. Now, a quick word on juries. Juries are exceptional in Hong Kong, even in criminal cases. As I said, they're used only in serious cases in what's called the court of first instance. So if you're tried in a magistrate's court, there's no jury in a district court. Court of first instance only. Most criminal cases are decided by a judge or magistrate without a jury. Even a serious criminal case today may have no jury if it is held to be a matter of national security and if the Secretary for Justice orders a no jury trial. So juries quite exceptional in criminal cases, but in civil cases, juries are highly exceptional and only found in the odd jury case, like Lu and Chan, where one party asks for a jury and the judge has no objection. Now, even if one party asks for a jury, the judge can say, no, there are going to be really technical issues here, and we shouldn't leave it to amateur jurors. This should be heard by a court, by a judge. Are civil juries a good thing? The problem is that unlike judges, juries do not have to give reasons for their decisions. So on appeal, in the Lu and Chan case, the appeal courts knew what the jury had decided, but they could only guess why they decided as they did. Okay? So a lot of criticism of juries, not just in civil cases, in criminal cases generally, is they don't give reasons. Now, if a judge gives a reason for his decision, if you're unhappy with that, you can appeal it and say, that reasoning was defective. But when a jury says you're guilty, or you're not guilty, or there's defamation here, or there isn't defamation here, it's very difficult to know on what basis they made that decision, and therefore far more difficult to satisfactorily draw up grounds of appeal. Now let me talk to you about a few strange jury decisions. There is often, because they don't give reasons, no explanation why juries give one plaintiff a very small damages award. They've found in favor of the plaintiff. They've said, yes, there's a defamation here, but the award is quite trivial. You know, the jury decides how much, and it might say, no, we're not giving, we just give you a few pounds in England or a few dollars here. On the other hand, in other cases, which don't seem any more deserving, they give a very generous award. Sometimes for a defamation that doesn't seem very damaging. So, for example, any of you heard of Elton John? Please say yes. Right, okay. The Elton John case. Now, the case is called John and MGN, and in this case, a jury awarded the singer-musician Elton John over $350,000 in total because the defendants had said Elton John had an eating disorder and was on a crank diet. Serious or not? Would you be more concerned if someone called you a thief or a rapist? Yeah? Rather than, oh, you've got an eating disorder. I mean, it may be defamatory, but it surely is not that serious. But they gave him £350,000. Now, we can break that down. They gave him ordinary compensatory damages, and then they added to that something called exemplary damages. And I'll very quickly explain what that means. Normally, damages, whether it's in contract or in tort, are to compensate. But in tort, there's a possibility of giving exemplary damages to punish the defendant, to make sure that he doesn't benefit from the commission of a tort. For example, you might write a book about me, which is very, very defamatory, and you sell millions of copies. The court decides that my reputation is worth about $50,000, but you've made $1 million from selling the book. Exemplary damages operate to make sure that you give that money up so you don't benefit from the commission of your tort. Exemplary damages are awarded against you. The rather strange thing about that is that it doesn't go into the public purse to boost the legal aid fund or whatever. It goes to me, the plaintiff. So we make sure, do not benefit from the commission of your tort, but I do very nicely because you've sold all these copies. I get, as it were, overcompensated because my reputation is not worth as much as the court ends up giving me. Now, in this case, Elton John got exemplary damages. It was presumably thought that the people, writing this story were really improving their circulation figures and had calculated that they'd make money out of it. But on appeal, the Court of Appeal said this was absolute nonsense to give him so much. And they reduced this to £40,000, a much more realistic figure. They're not saying it wasn't defamatory. They're simply saying that the jury has given you far too much. I'll quickly tell you about another case. This is someone you probably won't have heard of. Bruce Grobbelaar, who used to be a goalkeeper for Liverpool. And a newspaper had run this story, and what they'd done, they'd actually secretly tape conversations. And they said that Grobbelaar had taken money from a gambling syndicate. Remember, he's the goalkeeper, right? So he'd taken money from a gambling syndicate for throwing a game. In other words, letting goals in. And in court, he said, yeah, I did take the money, but I didn't deliberately let any goals in. Now, if you're on the jury, what would you think? If he took the money, that's still substantially true, isn't it? That he's corrupt. But no, the jury had to decide, well, even though he took the money, it's still a further defamation to say that he threw the games deliberately. He denies it, and very difficult to prove that somebody deliberately let a goal in. I mean, a goalkeeper can have a bad game, right? So, it was found that he had been defamed, but bizarrely, having already decided that he's wrongly taken money, a jury gave him £85,000. On appeal, that was reduced to £1. That's what the appeal court thought of Grobbelaar, obviously a lot less than the jury did. So, it's now very unusual to have a jury in a Hong Kong defamation case, and it's even more unusual in England, where the rule now is that there can only be a jury trial if the judge orders one. Now, this is a consequence of the 2013 Defamation Act, which reformed the law of defamation in England to some extent. It hasn't been followed in Hong Kong, so you've got slightly greater potential for a jury trial in Hong Kong. But as far as England is concerned, it's not a matter for the parties. It's not a question of you saying, I'd like to have a jury, please. No, it's for the judge to say, this is the sort of case where we should have a jury. Frankly, this is very unlikely ever to happen. And now, something that I think, in many ways, is the most troublesome of all of Tony Weir's oddities. There is no legal aid in defamation. Now, a very quick, what do we mean by legal aid? The idea in UK and in Hong Kong is that people who cannot afford to bring or defend legal aid should get support from the state. Okay? That's broadly what legal aid is. Now, we can have legal aid in criminal cases. In fact, it's much more likely there because the courts will always say, well, hang on, this is serious. Someone's been charged with a crime. They ought to be able to defend themselves. And if they can't represent themselves articulately, they should have a lawyer. And if they're poor, they need support. The way that it works in civil cases is that we have what's called a merits test and a means test. So first, the Legal Aid Board, which supervises the legal aid system, decides merit. Is this a suitable case to bring if you're the plaintiff? Okay? Does it have, well, they probably work on this basis, does it have a reasonable chance of success? Although that's not strictly what the rules say, it's how they are interpreted by the Legal Aid Board, it's how it works. So you've got to have a reasonable case. Then the second thing, probably more important, a means test. So those who are poor, under a certain amount, get free legal aid. Those who are rich get none. Maybe exception in a really serious murder case, even a rich defendant may get some legal aid. But basically, poorest get free legal aid, the rich get nothing. In between is sandwiched, the so-called sandwich class, and they may well get some legal aid, but they will have to pay a contribution towards their costs. Okay, so that's broadly how it works. In defamation, no legal aid. Now, this support then is available to every sort of case except defamation. So why the exception? All right, it may be thought, if you treat your reputation as so important that you want to sue someone you think's offended your reputation, okay, spend your own money. We've got better uses of public money to spend on people who've been seriously injured in accidents and so on and that. If you want to bring a defamation case, you've got to finance it. Okay? Now, to that, in some of the damages awards to which I referred, okay? Very generous award to Elton John. Okay? Now, this is what the judges in England have started saying. Is it right that you should be giving someone the sort of money which is in excess of a poor guy who, as the result of someone else's negligence, is rendered paraplegic? They can't use any of their limbs as a result of the admitted negligence of the defendant. And yet, some of those awards are actually lower than the sort of award that a jury gave to Elton John. Is that right? Someone's accused you of having an eating disorder versus someone has just knocked you down and meant that you will effectively be, if you like, a cabbage for the rest of your life. You know, surely that's disproportionate. Now, in the same way, you might say, why should the state finance people who want to protect their reputation? That's a matter for them. And that may be fair enough. But the no legal aid also applies to defendants. Okay? So if I sue you for defamation, you're there minding your own business, you've said something about me, now I sue you, you can't get legal aid, and there's a risk of you going bankrupt, losing all your money, just because I pick on you. That can be very significant in the case of a big company picking on a small person who's offended them. And we're going to look at a couple of examples. So, providing money should be for the biggest cases, perhaps. But But the rule also applies to defendants. So it's not just the person who brings the action who is denied legal aid. The person being sued is also barred from getting legal aid. And this can work very unfairly. We're going to look very soon at a couple of examples. If a poor defendant, without the means to pay for a lawyer and denied legal aid, insults a rich, powerful group or company, that group or company may sue the poor defendant, and even if the defendant wins, he or she may end up losing money defending the action. In short, there is scope for bullying. Now, this is a point to make. It tends to be the case in law that even if you win, you're still out of pocket. Of course, you've spent your time, but you've also spent your money. Generally speaking, costs follow the action. If you win the case, the other side has to pay your costs. But they are never enough, actually, to cover your real full costs. So going to law is expensive, even if you win. Scope for bullying. Leading tort academic Paul Igilica describes this as, I've got a missing D. Abuses of power by companies which use the threat of litigation, that means legal action, to discourage defendants from criticizing their activities. And our first and very famous example, the McLibel cases. In McDonald's Corporation and Steele and Morris, McDonald's, yes, the burger people, sued two environmental activists who had made a huge raft of complaints against McDonald's, their poor environmental record, their poor employment practices, etc., etc. So these two were very, very uncomplimentary about McDonald's. Now, it's almost, they were, if you like, vegetarian activists. They don't like the whole idea of people eating meat, but nonetheless, they said specifically, McDonald's, so they will be buying meat from places in the world where it's environmentally damaging to do this, and so on and so on and so on. So a huge raft of complaints. The case dragged on for 10 years. Just imagine how expensive that is. 10 years. The plaintiffs, McDonald's, spent millions on the case. The defendants spent thousands. Obviously, they didn't have millions. Now, a curious feature of the case, and a rather worrying one, is that the female defendant, Steele, was actually tricked by an undercover policeman into having a relationship with him. He, as it were, was trying to infiltrate pressure groups to get information on possible troublemakers. There was a big question mark as to whether he was at least sharing information, even if not implicitly employed by McDonald's. In other words, that this was a dirty tricks campaign. I think it's fair to say that wasn't actually established, but there were certainly great suspicions of this. So, the defendants lost. Some of their criticisms were upheld, but the defendants lost and were ordered to pay damages. Now, one of the things is that if I say that you've defamed me, and I give a list of 10 defamations, if I can only substantiate 6 of them, there are still 4, and I can still be liable. Now, there's a slight exception, and that is if the things I've proved about you are so awful, so that the things I haven't proved are so minor that they wouldn't really adversely affect your reputation, given what I have proved about you, then no liability. But in this case, yes, we accept some environmental damage. we don't necessarily accept the employment practices, etc., and therefore you're going to have to lose the case and you're going to have to pay damages. Now remember, they started off with no money. They were only sort of financed by kind of GoFundMe things, you know, that kind of thing. McDonald's, however, did say, we're not interested in the money, we just wanted to clear our reputation. Now, the defendants have lost. They then appeal unsuccessfully to the UK House of Lords, the highest court in the UK at the time, now replaced by the UK Supreme Court. Again, they lost there. But Morrison Steele then appealed to the European Court of Human Rights. The European Court of Rights held that the defendants had not received a fair trial. There was inequality of arms because of their lack of legal aid. Moreover, they should have been allowed to speak out on a matter of public interest, the right to freedom of expression. So let me explain those two, okay? It is possible, in addition to, if you like, narrow legalistic grounds, for there to be an appeal to the European Court of Human Rights on the basis that your human rights have been infringed. And amongst those human rights, one, the right to freedom of expression. Of course, defamation always involves a balance between freedom of expression and the right to a reputation. And the law of defamation is said to be this balance, what Tony Weir calls the battle between good and good. Your right to reputation, but his right to freedom of expression. And you've got, as a court, to try to find that balance. The European Court believed that the English courts had not got that balance. There should have been a right to freedom of expression and a right to a fair trial, another human right, which must involve you having the same sort of legal support as the other guy. Whereas instead, this is what we mean by inequality of arms, McDonald's have all the money in the world to spend on lawyers, and Morrison still don't. They have essentially to present their own case. And obviously, that's why we spend so much time and money training lawyers. If you've got a lawyer, you've got a better chance. So, inequality of arms. So this is what happened. The European Court fined the British government, not McDonald's. The British government, through its, the way, for example, that the defamation laws are constructed, the absence of legal aid, has meant that these two people's human rights to a fair trial had been impaired. A second example. In the British Chiropractic Association and Simon Singh, this went to the English Court of Appeal. Singh had written for the newspaper, The Guardian. He wrote as their science writer that chiropractic practice used in respect of children's ailments such as colic and asthma had no scientific basis. And the chiropractors sued him. Now, he didn't say chiropractic is rubbish, it's nonsense, doesn't work. He didn't say that, but he said there's no scientific evidence that it works in these two cases. So, he was sued. The chiropractors had won before the famous London libel judge, Justice Eadie, at what we call first instance. That's the first trial. But it then went to appeal. Singh challenged the judgment on appeal, and he went to the English Court of Appeal. But the case was never heard, because at this point, the chiropractor said, okay, we give up. And that's it. So he won. But it was estimated that in order to win, it had cost him £20,000 of his own money. Okay? So look again at how you can bully people. We'll sue you. We'll bring an action. You've got to defend it. You've got to give up your time. You've got to spend some of your own money, even if you get, and you can't get legal aid again, remember. All right, you're going to get costs, but they won't fully reflect your actual cost. And so he won, but it cost him a lot of money. There is, incidentally, now, since the 2013 Defamation Act in England, there are reforms whereby if he had, if his article had been peer-reviewed and was serious scientific, on a serious scientific basis, that the case could not have proceeded. He could not have been sued in defamation. But at the time, he was. So again, this idea of bullying. And I'm just about to conclude. Although defamation juries are almost extinct in Hong Kong and England, Tony Weir's other two oddities still remain. So, it is still not possible to defame the dead, even though it may well offend, those loved ones who remain. And it's still not possible in England and Hong Kong to get legal aid to bring or defend a defamation case. Thank you.
Thank you very much, Mick, and I'm glad you didn't say goodbye because as we mentioned earlier, for those of you who study with, decide to come and study with Hong Kong U SPACE, Mick Fisher, who set up some of our main law programs, is returning both to teach, and you're writing the course manuals on some others, aren't you? Yes. So wherever you study with us, you probably will come across Mick's work.
Not escape.
Now, does anyone want to ask any questions, either about what Mick said or about studying here generally?
I am absolutely, fine if you have any questions.
I just mentioned one thing I forgot to mention at the start. It was very apt that Mick was giving a presentation primarily on English law, weren't you? But you mixed in with some Hong Kong law. Remember again the title of this course, Graduate Diploma in English and Hong Kong Law. When we're here at Hong Kong U SPACE, of course, we're primarily preparing you for practicing as lawyers in Hong Kong, but we also recognize that students want to know English law, and so we also have English law in the courses, and we find that it provides a very good mixture for students preparing that way. Just going once again on any questions? The other thing you'll find at Hong Kong U SPACE also is that we stay behind, don't we, to answer questions. So if anyone is too shy to ask questions right now, you're welcome to come up to us individually. But in the meantime, I'd like to thank Mick Fisher again. And Mick, stay here. You can take a photo. Thank you very much for coming back to Hong Kong U SPACE.
My pleasure.
It's all about the law of tort. Got that, Helen, and it's not finished. You can keep this one.
Thank you. Oh, thank you very much indeed. Thank you.
If you look up at Helen. Okay, let's give Mick Fisher one more round of applause. And thank you all very much, whether you're here in the room or I know there are many of you watching online. Thank you for joining us today. We're always very pleased to have people interested in law and other subjects coming to Hong Kong U SPACE. And if any of you want to talk to either me or Mick individually, please do feel free to come up and